Alex here with part 100 of the My Docket series on child custody and visitation. As with my previous videos, I will take this opportunity to direct my viewers to part 0. If they haven't seen it yet, please take a look at that video. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed, cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my year-long high conflict child custody ordeal from beginning to end in chronological order. We go into the court's order at this point. The court denies any access to that information regarding my ex's mental health records. I do remember being dismayed at seeing this order come through, and this order actually was instrumental in adjusting my mindset going forward. When the court entered this order, it really sunk into me that this was not a judge who cared about the best interest of the child. It was just a judge who wanted the case to go away. It was a judge who pretty much led to the embodiment of everything I mentioned in the video. End of filings is not end of abuse. And, before I got to this point, I kind of thought to myself that things would have failed even if I proceeded on this educational issue because of the judge's exercise of discretion, because of his mindset, his worldview, and all that stuff. But it really didn't sink in until I started this video that it wasn't just that it was just the judge's sort of way of thinking. The judge's actions throughout the case, the orders he entered, the way he communicated with us, these are the things that gave me the signals that he wasn't going to really do anything to protect the child. So earlier, it was almost like one of those things of this approach was doomed to fail and there was nothing I could do about it. But by the time I got to this video, I worked through all the documentation that was filed, I got to this order denying, I really started to get that these things aren't just sort of happening. It's not like these things are completely random. It's not like I just got bad luck. It's this judge, this guy's a problem. And it's crazy because when I completed my case and I looked back, I kind of weighed the pros and cons of his approach. And earlier on, he helped, and then later on, he really got in the way. And then I think I did a video on this topic where if you ask a judge for something that they give to most litigants and you don't have an attorney, you're probably going to get it. They'll probably help you there. They'll help you on your way there. And if you start to ask them for things that are exceptions to the rule that not many litigants get and you don't have an attorney, then they'll probably try and get in your way. But when I kind of came to those understandings, it was less of an emotional, more of a matter of fact understanding. And it was almost like I began to forget the frustration because I was already out. I'm still doing the videos to help everyone. I'm giving everybody My Docket videos and the high conflict child custody videos, legal nuts and bolts videos, and I'm still there for all of you. But then when I got through this point in the series, a lot of those emotions kind of came back out, and I was like, I've already said on the channel that what the judiciary is doing throughout these 50 states, specifically the family divisions of the judiciary, what they're doing is wrong. It kind of reignited that fire in me that it's more than just wrong. It's like, it's almost to the point of criminal incompetence, which I don't even know if we have in the US. Other countries do have statutes where you can be held criminally incompetent, which means basically you're so incompetent that you're a criminal. I don't know. Like I said, I don't think we have that over here in the US. But anyway, it's like to that point. It's to the point where it's so bad that you should be fined or jailed. It's like, it goes too far out of the realm of oops, I made a mistake. It's like the attitude. It's almost brazen in my opinion. It's like I'm not going to do my job because I know better than the system, than the rules, than the Supreme Court, than blah blah blah. And what are you going to do about it? That part right there, that second part is kind of the attitude that I see not just with this judge but several other judges on the bench. It's sort of, here's what I'm going to do. What are you going to do about it? You can't do anything about it. You can't stop me. Ha ha. And it's a little, there was something in the protests, the George Floyd protests that came up that was kind of eye-opening for me. I can't remember who said it. It was a post somewhere on social media, but the person said, there's some irony here in the government asking, these protesters not to riot, not to resort to violence or force, And the irony is that they learned this from you. That people have learned that force is the only thing that triggers a response from the government, from the judges. And the reason I say that now has nothing to do with taking advantage of the protests that are going on in the country. The reason I say that now is because that's what I've been saying on this channel since I started it. Over and over again, there are videos of me saying that the judges respond to force. The attorneys respond to force. They're not going to do the right thing, guys. I've said this since I started the channel. I've been saying that. And I've also stated it before in some of the interviews that I had with my position as administrator of Artivada judges, that it's unfortunate, but the reality is that these participants, the attorneys and the judges, respond to force, and that approach works. So it's all these things are sort of hitting me now. It's kind of a combination of my mindset before and then like my mindset now, the more, advanced, or I guess you could say the Alex that's past the struggle, the guy that's gotten through it all and it's behind him now. These two things are starting to harmonize in my head, and I'm starting to see that even, other people are starting to realize this. Other people are starting to figure out that the thing that's most effective at getting the government to do the right thing is to take that arm and twist it as hard as you can. That's literally what I've stated in previous videos. I got to the conclusion in my case by taking the judge's arm and twisting it as hard as I could. That's what the 4 appeals were. That's what the that's what the publication from the Supreme Court was. Those were not Alex asking kindly, please help my child. Those were Alex saying, help my child or else I will file an appeal. I will force you to protect this child. If you don't want to do it, I'm going to force you to do it. And that's what I did. So anyway, just a reminder that the Supreme Court order reversing, it's not a suggestion to a judge. That's a Supreme Court of Nevada commanding the judge to do what he should have done without having been told to do it. Anyway, I think at this point we can now just go ahead and take a look at what the judge has filed. Here we have the judge's order denying application to refer to the Discovery Commissioner, quashing subpoena, denying motion to compel, and regarding my ex's ex parte motion. Court has reviewed all those documents that I listed. I'm not going to go through them again, but in the first paragraph, it's a standard introductory paragraph. The court is summarizing the documents that have been reviewed. Next paragraph, the court is indicating that it has reviewed, looks like some more of the documentation that we've gone over recently. Pretty much he has looked at all of the motions, oppositions, and replies that have been filed. The court has also reviewed my application requesting referral to the Discovery Commissioner. And then next paragraph here is the summary of the facts, which is that we share a common minor child born in 2006. Scrolling down into the next paragraph, the court granted my request to have our child attend Coral Academy. Next paragraph here, the court has, based upon my motion requesting for modification of custody, set a hearing regarding child custody. In the underlying motion, I have alleged that my ex is sabotaging the child's education. Next assertion here is the application for referral to Discovery Commissioner. I'm asking that the Discovery motions be referred to the Commissioner pursuant to Rule 16.1D, subsection D1. He's obviously refused to do this because he's actually going to rule on this stuff on his own without referring it. It makes me wonder if he was worried that the Discovery Commissioner would have granted my request, because guys, 99.9% sure, and I'm not exaggerating with that outlandish percentage, the Discovery Commissioner would have approved what I was asking for because it was consistent with the law. So the only way for the judge to not embarrass himself is to rule on this on his own. Like that, to me, it's clear that stuff is relevant for a modification of custody. Next here we have the interest of judicial economy. That's what he calls it. What it really is the interest to deny the motion. Let's see. In my ex's motion, My ex argues that she has the right to protect the confidentiality of her medical records pursuant to Rule 45C and Statute 449-720. In my opposition, I refer to mental health related hospitalization, which occurred in 2008 before the Oh, so he was duped. Oh, yuck. Oh, I really hope he doesn't actually think what he's typing here. So I was hoping that he would use Rule 16. I still think that that's an inane way to go, but this is actually worse, because this means he's been successfully tricked into misunderstanding how res judicata principles work. I claim that my ex's right to privilege should be overcome by the fact that mental health of the parents is a factor, which it is under the law. I'm claiming that these two statutes provide an exception to privilege because it's a proceeding related to abuse and neglect of a person with a disability. I'm also arguing that a subpoena is within general provisions of discovery pursuant to Rule 26.b1. I'm claiming that I am willing to stipulate to a protective order. In my ex's reply, she argues that the incident of 2008 is remote and that it was considered by the court. Okay, so she's still trying to drive he's recognizing that she's trying to drive the res judicata principles. Let's see here. My ex argues that I am trying to get a backdoor access to her confidential psychological and mental health records. Here we go into the next paragraph. The right to obtain information and documents in civil litigation is set forth in 16.1 and 26, but these rules address only a party's right to conduct pretrial discovery. 16.21 addresses post-judgment discovery. This is what I was thinking he was going to use. No statute. Once a final judgment has been entered, discovery proceedings are presumptively unnecessary. That's not true. I don't believe that's what they say in the rule. So he's taking a few liberties here. Let's take a look at the next paragraph. Additionally, post-divorce discovery leads to heightened potential for abuse. However, a court has the inherent power to control it by virtue of its right to control the disposition of causes on its docket with the economy of time and effort for itself, counsel, and litigants. He cites these two ancient cases. This one here from 1936, this one from 1973. That one's not as old, but it's still pretty old. Court retains jurisdiction over certain issues. It may permit. So this is making it seem like the court has an option to just decide not to do it, but this isn't true because this could violate due process, which it's Fourth Amendment issues that he's dealing with here. I don't think he understands that. He's saying he has the discretion to order post-judgment discovery. It's true that he has the discretion, but he cannot abuse that discretion. So let's continue and see what he does. Post-decree discovery will be permitted only when the requesting party can justify the burden imposed upon the responding party. Okay, that statement there, if true, would be something that would help him, but look, there's no citation. He doesn't cite any rule or statute. He's just inventing this. This is his opinion. So in his opinion, this is what he thinks is true. The burden is met by showing good cause for a specific discovery sought, with an emphasis on the nexus between the discovery sought and the issue or issues before the court. In this regard, the court can require... Okay, he's twisting himself into a logical pretzel to lead into the conclusion of denial. I do eventually nail him on an appeal when he does this, but it's not on this issue. I get him later on. I failed to request permission of this court to conduct post-decree discovery. That's what I am doing in my motion. So he's basically buying the argument that my ex's attorney made, which is that he wants there to be a process before the process, which is ironic because earlier in this document he says he wants to limit the costs of the attorney fees and costs incurred by the parties. But this here it's a contradiction with his earlier statement, because he's actually saying that asking for discovery in the motion itself is not good enough, and that I have to ask for discovery before discovery prior to this point in time. Which, by the way, guys, I doubt that he actually engages in this practice. I have a suspicion that this is just something that he did in my case only, and that in other cases, especially if attorneys are asking to do what I was trying to do, he probably went along with what the attorney said. I'll talk about this more about why it happens in the video self-representation bias. Next paragraph, we have Rule 45, subsection C3A, timely motion by the court. So he's going into the quash authority here. He says that I first claimed that there should be an exception overcoming the privilege because this is a child custody action, mental health of a parent's. Oh my God, this is... Okay, hold on a second. The court finds that the argument is unpersuasive. If the court were to accept this claim, then no privilege for mental health records would ever apply in a custody dispute. Is that an argument? What? So first of all, most of the time, yeah, mental health records are relevant. So he's trying to act like that's a shocker. Okay, Additionally, father does not allege any mental health incident or hospitalization has occurred since the incident in 2008. So this is him using the wrong principle of so he's committing a legal error. Okay, so in the initial part of the paragraph, he's abusing his discretion, and then in the second part of this paragraph, he's committing a legal error because he just doesn't understand how res judicata principles work. Scrolling a little bit further, I claim that under the law, there's an exception to the privilege. In the case which there's multiple exceptions. Despite my argument to the contrary, the proceedings are not abuse. Okay, so this is another thing that he does. This isn't the first time he's done this. So what he's doing, it's almost the same thing as what a high conflict X will do. He's finding a plausible explanation to support his erroneous conclusion. So what he has done is he's decided to use a statute that defines abuse and neglect proceedings, and he's trying to say that because that statute comes from a different statutory scheme, then that doesn't apply to this case, and therefore this exception doesn't trigger. But in reality, that's not how the law works. If a statutory definition does not apply, then you fall back on Black's Law Dictionary. And if Black's Law Dictionary does not apply, then you fall back on the ordinary dictionary. You don't say, well, since this law doesn't apply to this case, then there is no such thing as abuse or neglect in these types of cases. That's what he's doing. He's basically saying that since abuse and neglect is not defined in the child custody statutory scheme, and since that term is only defined in the abuse and neglect scheme, then that can never possibly apply to a child custody case. These statements are so bad that if I had the experience now that I had then, I might have filed a complaint with the Commission on Judicial Discipline. But at the time, I didn't know what I know now. I also strongly suspect that they would have never taken this approach had I had an attorney, because they would have been concerned that the attorney that I had would have gone ballistic, which they probably would have. Guys, the thing about this case is it's not like the judge is just going up to the line and stopping. He's going way off the reservation. He's doing things that are completely out of bounds, things that are so far off that they make no sense at all. We're going to go ahead and continue now. But I need to pause there for a moment and say it's not a complete shocker that he's doing these things, because this is the same judge that ordered our child to be exchanged at midnight. Anytime I wonder, is this judge just having a bad day? Like, is there something wrong with him just for this day? I take a step back and I go, hold on a second. This is the same guy that ordered midnight exchanges with a 2-year-old child. And not only once, but 3 times he ordered it. So this isn't something that is out of character for him. He does things that don't make any sense. Moving on to the next paragraph, we have, based on the foregoing, my subpoena ducus tecum to West Hills Hospital is quashed. Okay, guys, so I think that had I appealed this, which at this time I hadn't won any appeals, so I don't think I did. I might have appealed it, but I don't think I did. Had I appealed this on the res judicata principles, 100% chance it would have reversed. The Supreme Court of Nevada would have overturned his decision as legally erroneous. On the 16.21, I feel like they most likely would have reversed. There is a small chance that they might have agreed with him and said that I need to do a motion to open post-judgment discovery prior to doing any other motions. That extra step. Again, guys, there's no authority that says you have to do this, but I feel like there is a small chance that they might have sided with him just on that alone. But all the other stuff that he said they would have just thrown in the garbage. None of that stuff was applicable at all. Scrolling down here, motion to compel disclosure of the psychiatric and psychological providers. I feel like this is going to be the same thing, but we'll take a quick look here. Restates my factual allegations in citing the 2008 attempt. I restate many of the legal arguments made. I include my best interest analysis, which the court has to conduct. I want my ex to disclose the provider so that I can subpoena them. Going into the next paragraph here. In my ex's opposition, she restates many of the arguments raised in her motion, of course. In my reply, I restate many of the arguments, of course. I'm claiming that the motion to compel is in itself a request for leave to conduct discovery. Okay, so it's nice that he's recognizing that under Rule 16.21 that I am actually trying to request leave to conduct discovery. So, I mean, I was worried that he was just going to pretend that he didn't know that I was trying to do that. I claim that I only need my ex's psychological information. As discussed above, the court is... So he's taking advantage of this argument. He's going to use Rule 16.21 to deny. However, he's going to construe my motion as a request. Okay, that's good. So let's see what he uses. He's going to use res judicata then again, because he does block this. Post-judgment discovery will be permitted only... Okay, so we already talked about this. I'm asking my ex to be ordered to disclose her psychiatric and psychological care providers. We already talked about this. If I were to subpoena the care providers, it would likely lead to motions to quash, similar to the one that. Okay, so yes, he's relying on the same res judicata principles. He's also stating that the information that I'm trying to get is privileged. Again, no citations, none. He's just inventing these ideas. Based on the foregoing, my motion to compel is denied. Going into the next document, we have a notice of change of address. I've gone over these a multitude of times. Definitely take a look at my video, notice of change of address, to understand why it's important that you file these, because it can impact your right to being served under Rule 5, at least in Nevada. And we have the certificate of Rule 5 service indicating that I personally served this notice of change of address upon my ex's attorney at her law firm. Going into the aftermath, I filed one document, but it was a free filing, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees, and my ex's attorney would have probably spent 5 minutes putting my notice of change of address in her computer system just to update her records, and maybe 10 minutes looking at the order denying, because it doesn't require her to do anything. It basically makes her life easier. She's going to be able to go to the court and represent my ex at this trial, and a lot of the evidence that would have explained why she was intentionally sabotaging our child's education has been suppressed. And this is one of the things that attorneys do, and this is one of the things that sometimes an incompetent judge will facilitate. And still engineer a specific outcome by sweeping evidence under the rug, hiding evidence. It's ironic because a lot of times the judges complain about not having the evidence to make the decision they needed, but then in cases like this, they'll actually take actions that hide the evidence that would have helped them make the decision that they needed to make. I'm going to go ahead and wrap things up now. If you have any questions, feel free to post them down in the comments below, and I will see you guys next time.